Witness Mike Judy, test 1, 2, 3, 4. Thank you. Chair Mike Judy, 1, 2, 3.
The Subcommittee on Regulatory Reform, Commercial and Antitrust Law will come to order. I apologize, first of all. We had votes and tried to get through them as quickly as possible. Without objection, the chair is authorized to declare a recess of the committee at any time. We welcome everyone here to today's hearing on the Chevron Doctrine, Constitutional and Statutory questions of judicial deference to agencies. And I now recognize myself for an opening statement. Today's hearing on the 30-plus-year-old Chevron doctrine presents interesting questions on the current state of the separation of powers and the role of today's administrative state. These questions directly address the way our tripartite system of government works. For one, has judicial review of agency action evolved in a manner that respects the Constitution and the roles intended for the legislative, executive, and judicial branches? If there are issues, what can and should Congress do to address them? In Chevron, the Supreme Court established a framework for how courts should review an agency's interpretation of a statute it administers. As a threshold matter, the court must determine whether the statute at hand clearly speaks to the question addressed by the agency action. If it does, then the court must conclude that the agency acted as Congress willed it. But if the statute is silent or ambiguous and congressional intent is not clear, then the court must consider whether or not the agency's interpretation is based on a permissible construction of the statute. If it is, then the court defers to the agency's interpretation. Although the Chevron doctrine is not as glamorous or headline-worthy as some other issues we face in Congress, its indirect effect on the everyday lives of Americans cannot be understated. Its implications for the balance between the three branches of our government can be quite severe. In fact, many of the most significant decisions of the Supreme Court in recent memory centered on questions of administrative law. The focus is often on how agency officials interpreted a statute rather than the substance of the statute itself as enacted by elected members of Congress. In this environment, Chevron and the cases that followed have caused confusion instead of stability in the rulemaking process. In Marbury versus Madison, among the earliest precedents set by the court, Chief Justice Marshall declared that, quote, "It is the province and duty of the Judicial Department to say what the law is," end quote. By mandating deference to agency interpretations of statutes, however, the judiciary has arguably stripped its own ability and charge to do just that. For those of us up here on the dais, Chevron raises additional concerns. Throughout my time in Congress, and as a member of the Judiciary Committee, I have decried the breadth and decree to which Congress has ceded its power to the executive branch and its agencies. Over 30 years of Chevron deference, we have seen the gradual creep of executive agencies from administrators of the legislative process to becoming legislators themselves. As Justice Thomas noted in his concurrence to the court's Michigan v. EPA decision from last summer, quote, "Statutory ambiguity thus becomes an implicit delegation of rulemaking authority, and that authority is used not to find the best meaning of the text, but to formulate legally binding rules to fill in gaps based on policy judgments made by the agency rather than Congress," end quote. In short, rather than executing the will of Congress, as set forth clearly through statute, agencies now have the freedom to define the law as they see fit. Some may argue that even the use of Chevron could be avoided by clearer legislation. This is true and should be a goal for all Congress, but as long as Chevron stands, it still would not eliminate the opportunity and incentives for unelected bureaucrats removed from the effects of their actions to set policy for our entire nation. And we have seen it with just a small sample of overreaching EPA regulations like the Clean Power Plan, Waters of the U.S., and the Utility M Act rule found invalid in Michigan v. EPA. The possibility of Chevron deference encourages a search by those inside and outside of government for ambiguity in a statute that allows them to engage in creative rulemaking to accomplish whatever goals an agency or organization may have. Today, we get to examine all of these results. We are fortunate to have an excellent panel of witnesses before us to present a variety of views, and I look forward to hearing from each of you. The chair now recognizes the ranking member of the Subcommittee on Regulatory Reform, Commercial and Antitrust Law, my friend Mr. Johnson from Georgia, for his opening statement.
Thank you, Mr. Chairman, and welcome everyone to this very riveting issue. Judicial review of final agency action is a hallmark of administrative law and is critical to ensuring that agency action does not harm or adversely affect the public. As the Supreme Court clarified recently, this significant policy concern has long supported a general rule favoring judicial review of agency action for arbitrariness and abuse of discretion, subject only to rare exceptions. But as the Supreme Court held in Chevron v. Natural Resources Defense Council, reviewing courts may only invalidate an agency action when it violates a constitutional provision or when the agency's rule exceeds its statutory authority to issue the rule as clearly expressed by Congress. For the past 30 years, this seminal decision has required deference to the substantive expertise and political accountability of federal agencies. Professor Ron Levin, chair of the Judicial Review Committee for the Administrative Conference of the United States, explains that this doctrine is born from principles of separation of powers, noting that it recognizes, recognizes that Congress often decides to entrust policymaking authority in certain areas. When it does so and the agency acts within the scope of that delegation, as the court understands it, a court is obliged to honor the legislature's expectations by upholding a rational exercise of that authority, even where the agency reaches a conclusion that the reviewing court would not have reached, end quote. Although Chevron has taken on talismanic qualities in recent years, courts retain an important role in determining whether an agency action is permissible or arbitrary and capricious under the Administrative Procedure Act. In 2011, the court indicated that at the very least there is substantial overlap between the second step of Chevron and, quote, hard look review, end quote, under the APA. And while there is no shortage of debate on the principles of judicial deference, as the American Bar Association Administrative Law Section noted in 2012, judicial review largely remains stable today, concluding that, quote, debate on these principles continues, but the prevailing system works reasonably well, and no need for legislative intervention to revise these principles is apparent, end quote. I similarly oppose any attempt to abolish judicial deference through legislation. While I consider myself an ardent protector of the courts, it is well-established doctrine that the province of the courts is deciding matters of the law, not substantive matters specifically delegated to agencies by Congress. Since the 112th Congress, many of the majority's deregulatory bills we have considered would enlist generalist courts to supplant the expertise and political accountability of agencies in the rulemaking process. Compare this approach with other deregulatory bills passed by Congress, which would greatly diminish judicial review over deregulatory actions. For example, the House adopted an amendment to H.R. 8, the North American Energy Security and Infrastructure Act of 2015, which reduced the statute of limitations for judicial review to just 90 days for certain energy claims. immunizing certain energy projects from public accountability. In other words, the majority wants it both ways. When it benefits corporate interests, the regulatory legislation dramatically increases the judicial review of new regulations, threatening to impose years of delay and untold cost on taxpayers. When it benefits the public or our environment, deregulatory legislation closes the courthouse doors through sweeping restrictions on the court's inability to provide relief. So we have one set of rules for consumers and one set of rules for corporations. These proposals, which are transparently the design of the donor class to minimize their exposure to legal accountability, are just another example of how some not only want to allow the fox to guard the chicken coop, they want the fox to install the chicken wire as well. In closing, I look forward to testimony from our esteemed panel. Pardon my attempt at humor, and I thank the witnesses for their testimony, and I yield back.
The chairman of the full Judiciary Committee, Chairman Goodlatte, has been detained. He may show up, but in the event he does not, without objection, I offer his opening statement to be entered into the record. Hearing none, so ordered. The chair now recognizes the full Judiciary Committee ranking member, Mr. Conyers of Michigan, for his opening statement.
Thank you, Mr. Chairman. My colleagues, today's hearing focuses on whether the Supreme Court's articulation of judicial deference in Chevron is a concept that should be retained in federal administrative law. I believe the Chevron doctrine should be retained for several reasons. First, enhanced judicial review would make rulemaking even more costly and time-consuming for agencies. The federal rulemaking process is already deeply ossified, as they say. As the nation's leading administrative law scholars have long observed, agency rulemaking is hampered by burdens imposed by both the courts and Congress. Indeed, Professor Richard Pierce, one of our witnesses, noted that more than 20 years ago that the judicial branch is responsible for most of the ossification of the rulemaking process. Heightened judicial review would only worsen this problem because it would force agencies to formulate even more detailed factual records and explanations. Enhanced judicial review could also have the perverse effect of undermining agency accountability and transparency. It could encourage agencies to conduct rulemaking out of the public view, to issue guidance documents in lieu of rulemaking, or to cause them to avoid rulemaking altogether. I'm also concerned that the enhanced judicial review will undermine public participation in the rulemaking process. As the Nonpartisan Congressional Research Service has observed, public participation in agency decision-making is highly sensitive to cost and delay. And applying greater judicial scrutiny of agency rulemaking will favor those who can afford these greater costs. Large corporate interests, which are accountable only to shareholders and devoted to maximizing profits, already have the edge with their vast resources to bury an agency in paperwork demands and litigation with a goal of weakening regulatory standards. Rather than providing even more opportunities for the voices of corporate interests to prevail, we should be considering ways to ensure that voices of the public are strengthened in the rulemaking process. And finally, enhanced judicial review would encourage judicial activism. A less deferential judicial review standard would allow judges, in my view, to effectively make public policy from the bench while lacking the specialized expertise that agencies possess. The Supreme Court has had numerous opportunities to expand judicial review of rulemaking, but it has consistently rejected this approach. This reflects its long-held belief that generalist courts lack the subject matter expertise of agencies, are politically unaccountable, and should not engage in making substantive determinations from the bench. Enhanced judicial review, on the other hand, would allow general courts to impose their rules, to impose their personal policy preferences. It's ironic that the majority, which has long decried judicial activism, now seeks to give the judiciary a greater role in agency rulemaking. And what would be the impact of slowing down the rulemaking process? It means that rules intended to protect the health and safety of American citizens would would take longer to promulgate and become effective. This means a delay for regulations that protect the quality of the air we breathe and the safety of the water we drink and the food we consume. And so I welcome the witnesses, look forward to their testimony, and return any time that I may not have used. Thank you.
Without objection, other members' opening statements will be made part of the record. I will begin now by swearing in our witnesses before I introduce you, so would you please stand and raise your right hand? Do you swear that the testimony you're about to give before this committee is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may be seated. Let the record reflect that all the witnesses have responded in the affirmative. I'm going to go through each one of your bios, and then we'll come back and start with questioning. Okay. Jonathan Turley is the Shapiro Professor of Public Interest Law at the George Washington University Law School. He has served as counsel in some of the most notable cases of the last 2 decades, has served as a consultant on Homeland Security and constitutional issues, and is a frequent expert witness for Congress on constitutional and statutory issues. As a nationally recognized legal scholar, Professor Turley has written extensively in a range of areas. His articles have appeared in a variety of leading law journals and national newspapers, and he also contributes regularly to nationally syndicated news outlets. He is ranked 38th in the top 100 most public intellectuals and was found to be the 2nd most cited law professor in the country. Professor Turley earned his bachelor's degree from the University of Chicago and his law degree from Northwestern University. Welcome, Professor.
Thank you, sir.
John Duffy is the Samuel H. McCoy Professor of Law at the University of Virginia Law School. Prior to joining UVA's law school, Professor Duffy taught at the George Washington, Benjamin N. Cardozo, and William and Mary Schools of Law, as well as the University of Chicago. Professor Duffy also served as an attorney advisor in the Department of Justice's Office of Legal Counsel and practiced law with the firm of Covington and Burling. Professor Duffy is widely published and the co-author of a casebook on patent law. Professor Duffy earned his bachelor's degree in physics from Harvard University and his law degree from the University of Chicago, where he served as articles editor of the Law Review. Professor Duffy clerked for Judge Stephen Williams on the U.S. Court of Appeals for the D.C. Circuit and for the late U.S. Supreme Court Justice Antonin Scalia. Mr. Shepard is a professor at the Emory University School of Law. Prior to that, he served as a visiting professor of law at the University of Dresden in Germany and a lecturer for Kaplan Bar Review. Mr. Shepard practiced commercial litigation and bankruptcy law at the firm of Howard Rice and in San Francisco, California. Professor Shepard's articles, working papers, and books have been featured in various national publications and leading law journals. He has appeared as an expert witness before various panels, as well as the Senate Committee on the Judiciary. Professor Shepard graduated summa cum laude from Yale with a degree in economics. He holds a law degree from the Harvard Law School and a PhD in economics from Stanford University. Welcome, sir. Richard Pierce is the Lyle T. Alverson Professor of Law at George Washington University Law School. He has taught and researched in the fields of administrative law and regulatory practice for 38 years. Professor Pierce has taught at many law schools, including Columbia, SMU, the University of Kansas, the University of Virginia, and the Pittsburgh School of Law. Professor Pierce has published widely on administrative law and regulatory policy. His books and articles have been cited in hundreds of agency and court opinions, including over a dozen opinions of the United States Supreme Court. He is a member of the Administrative Conference of the United States. Professor Pierce served our country in the U.S. Coast Guard in various capacities. He earned his bachelor's degree in economics from Lehigh University. He holds a law degree from the University of Virginia School of Law, where he graduated Order of the Coif and served as managing editor of Law Review. Professor, welcome. Emily Hammond is the Associate Dean for Public Engagement and Professor of Law at the George Washington University Law School. Professor Hammond previously taught at several universities, including Wake Forest, the University of Oklahoma College of Law, the University of Texas, Florida State University, and the University of Georgia. Professor Hammond practiced law with Bondurant, Mixon, and Elmore in Atlanta, Georgia. As a former environmental engineer, her expertise included electricity markets, regulatory jurisdictions, and the various responses of legal institutions to scientific uncertainty. Professor Hammond's articles have appeared in numerous top-ranked journals, and she is a co-author of one of the nation's leading energy law texts. She is an elected member of the American Law Institute, a chair-elect of the Association of American Law Schools Administrative Law Section, and a member scholar of the Center for Progressive Reform. She has served as a hearing examiner for state administrative proceedings and has provided service to the International Atomic Energy Agency. Professor Hammond earned her bachelor's degree in economics from Virginia Tech and a JD from the University of Georgia. Welcome, Professor. Jack Beerman is the Harry Elwood Warren Scholar at the Boston University School of Law. He previously taught at various universities, including Harvard, DePaul, the Interdisciplinary Center in Herzliya, Israel, and the China University of Political Science and Law. Professor Beerman is published widely in top-ranked journals. He has authored and co-authored 4 books on administrative law, including a widely used case book and the Emmanuel Law Outline on the subject. Professor Beerman earned his bachelor's degree in political science and philosophy from the University of Wisconsin-Madison. He holds a law degree from the University of Chicago Law School, where he was elected Order of the Coif and served as an editor of the Law Review. Professor, welcome. Okay, we're going to begin with opening statements. We'll begin with Professor Turley, but before we do, there are lights in front of you, and I'm sure that several of you know what those lights are for. I'm colorblind, so I don't know what colors they are. So when I'd ask you to keep your statements 5 minutes or less, and if you start to go over, 5 minutes, I will diplomatically raise this little thing and tap here to get your attention. So I thank you, and I'd like to start with Professor Turley.
Thank you, Chairman Marino, Ranking Member Johnson, Ranking Committee Member Conyers, members of the subcommittee. It's a great honor to appear before you today to talk about the Chevron Doctrine, its constitutional implications for our system. It's a particular pleasure to appear on this esteemed panel with these academics, including my colleagues from GW, Dick Pierce and Emily Hammond, and my former colleague from GW, John Duffy, who left us to join some nest of Jeffersonians south from here. But we appreciate you allowing him to come back to the big city on occasion. This is obviously a very important question for many of us, but we look at it from different perspectives. I think what you're going to see today is sort of a microcosm of the field. How Chevron is viewed differs, whether you view it from a constitutional standpoint or from an administrative law standpoint, or perhaps a hybrid of those two areas. From my perspective, Chevron is a deeply problematic subject. I'd like to say, as Woody Allen once said, that I wish I could leave you with a positive point, but asked if you'd accept 2 negative points instead. From a Madisonian standpoint, I'm afraid the best you can hope for is to get 2 negative points to make a positive, but it doesn't quite work, and I'd like to explain why. I've previously testified and written about what is called the rise of the fourth branch, and how that has created an imbalance in our system and particularly drained away some of the authority from Congress, which is so important to the balance of our 3 branches. To take a look at the administrative state, as it's sometimes called, it's obvious that our system has changed. You know, when this republic started, we only had about 1,000 people in non-military positions. Obviously, it was quite small. In 2007, Congress enacted 138 public laws. In that same year, federal agencies enacted about 3,000 rules. To put it in a judicial standpoint, judges that year, in a given year, handle about 100,000 cases. Federal agencies have adjudicatory proceedings ranging around 1 million. The question then becomes, is the dominant source of lawmaking or law giving in the country? I think it is obvious that we have had a shift in gravity in our system towards this administrative state. The implications of that are worthy of discussion. They create new pathways and power centers in a system that wasn't designed for them. Now, my colleagues and I have different views of the implications of that. Chevron is one of those subjects that will deeply divide most academics. But in my view, Chevron was solving a problem that didn't exist. It, on its face, sought to limit the role of judges, which is not a bad thing in terms of agency decisions. But it had sort of Trojan horse aspects to it. It arrived in a benign form, and it became more aggressive and indeed menacing in time. Chevron allows a very permissive standard for agencies that has allowed the administrative state to be insulated to a degree that I think is in fact dangerous. Now, before Chevron, we didn't have a period of utter confusion or judicial tyranny. Under the Skidmore standard, agencies were given, quote, respect and considerable weight in their interpretations. That's why some of us view it as solving a problem that didn't really exist. And indeed, recently the court has almost a buyer's remorse in how it's tried to limit Chevron. You've seen in the Christensen case, for example, this limitation of Chevron to a force of law cases. You've seen in other cases how the court has tried to distinguish circumstances where Skidmore analysis would apply as opposed to Chevron analysis. But I think that one of the most problematic aspects of Chevron is seen in the City of Arlington case, where that deference was given to an agency in defining its own jurisdiction. In my testimony, I've recommended a series of possible approaches of Congress based on the delegation theory of Chevron that I have recommended, and I'd be happy to talk about those to the committee. And I will simply end by saying that I don't believe that you need to treat Chevron as a fait accompli or have a fatalistic view of Chevron. Chevron is not evil, it's not tyrannical, but that doesn't mean that it cannot be improved. And so I'm happy to answer your questions.
Thank you. Professor Duffy.
Thank you, Chairman Marino, Ranking Member Johnson, and distinguished members of the subcommittee. Thank you for inviting me to testify before you today. At the outset, I'd like to compliment the subcommittee for devoting time and attention to the Chevron doctrine. This single doctrine has enormous practical and theoretical importance in the courts, and yet it remains deeply controversial and confusing. I believe that the Congress could write and enact clarifying legislation to supplant Chevron with more theoretically sound and more easily understood principles. I want to begin with two significant missteps made in the Chevron opinion itself. First, and most importantly, the Supreme Court decided for itself, based on its own assessments of good policy and institutional competence, whether courts should defer to agency statutory interpretations. The court assumed, at least implicitly, that Congress did not have an opinion on the matter. That implicit assumption was wrong. If the court had considered statutory law, it would have found that the first sentence of Section 706 of the APA requires a reviewing court to decide all relevant questions of law. And it would have found that the text, structure, legislative history, and a consistent line of judicial precedents all supported reading that sentence as requiring de novo review of agency interpretations. Second, the Chevron court muddled the distinction between giving some weight to an agency's view as a part of the process of interpreting the statute and recognizing the scope of an agency's delegated rulemaking or lawmaking powers. Traditionally, courts engaged in statutory interpretations would not afford an agency's views significant weight if the agency had flip-flopped on its interpretation. The intuition here is easy to understand. Where an agency has held inconsistent views, the varying agency positions are simply unhelpful in determining a statute's meaning. By contrast, where an agency is wielding a delegated lawmaking power, courts fully expect administrative change. Indeed, the ability of an agency to change is part and parcel of a rulemaking power, which, as defined by the APA, encompasses not just the power to formulate rules, but also the power to amend and to repeal prior rules. Chevron blended these two concepts together. It treated the issue in the case as involving deference, but borrowed from the delegation theory the crucial point that agencies can change their positions with no penalty whatsoever. As shown in my written testimony, Chevron itself is an excellent demonstration of how agencies exercise their delegated rulemaking powers, and the government itself presented the case to the Supreme Court on a delegation theory. The court's articulation of a new theory of statutory interpretation was as unnecessary as it was unwarranted. Post-Chevron cases, especially United States versus Meade and King versus Burwell, had begun to reinterpret Chevron as a doctrine about delegation rather than deference. Nevertheless, corrective legislation would still be desirable because the case law remains deeply confusing. I believe legislation should be drafted around four principles. First and foremost, the Congress should reassert in the clearest possible terms that reviewing courts are to decide all questions of law and decide those questions de novo, without any deference to the administrative agency's positions. Second, the legislation should recognize that where Congress has delegated lawmaking powers to an agency, reviewing courts should give proper scope to those powers and allow the agency to write rules that are not arbitrary, capricious, or contrary to law. This principle would account for the actual result in the Chevron case, but would make clear that the agency's power is grounded in congressional delegation and not in deference. Third, Congress might also consider recognizing the traditional view that some administrative issues are mixed questions of law and fact, and the courts might properly give some deference to the agency's application of law to the facts of a particular case. Fourth and finally, Congress might also recognize the principle articulated by the Supreme Court in Skidmore versus Swift that in interpreting a statute de novo, courts may consider an agency's position as some evidence of a statute's meaning. Importantly, the agency would not have a power to control, but merely a power to persuade, a respect similar in kind to what might be afforded a prominent treatise or a nice law review article. Together, these principles would reaffirm what Congress previously codified in Section 706 of the APA and restore the court's traditional role, as articulated in Marbury versus Madison, to say what the law is. Thank you for your time and attention to these issues, and thank you again, Mr. Chairman, for the invitation to speak to the subcommittee.
Thank you. Dr. Shepard, please accept my apology for not referring to you as Dr. Shepard when I started reading your bio.
Thank you, Chairman Marino, Ranking Member Johnson, Ranking Committee Member Conyers, and the distinguished members of the subcommittee for the opportunity to testify today. Let me summarize my main point and then explain it in details. In the Chevron decision and cases following it, the courts held that reviewing courts must often give deference to agencies' legal interpretations. However, as Professor Duffy has noted, the Administrative Procedure Act said, and still says, the opposite. The APA explicitly says that there should be no deference on pure issues of law, and the APA's legislative history backs that up. Let me now discuss this in a bit more detail. The APA was a compromise between liberal New Dealers, including President Roosevelt, and conservative opponents of the New Deal. It is the Bill of Rights for the administrative state. It has remained in force with little change for 70 years. What does this founding document say about judicial review? The APA says that there should be no deference on issues of law. So here's the provision. It says scope of review. The reviewing court shall decide all relevant questions of law and interpret constitutional and statutory provisions. The provisions of the APA don't say anything about giving any deference on questions of law. If the drafters had wanted to, they knew how to create deference. Indeed, other nearby parts of the APA said that there should be deference on issues of fact. And the provision of the APA really means what it says. To see this, let's look at the legislative history. By the early 1940s, the courts had developed the following system. The courts said that there would be deference for agency decisions of fact and for agency decisions of mixed fact and law, but there would be no deference for decisions of law. At the time of the APA, everyone understood that the APA meant to codify and restate courts' existing approach. This was shown by the understanding of three groups. First, participants in the legislative process. Second, contemporary commentators. And finally, the courts. First, the participants in the legislative process said this. As the bill that became the APA worked its way through committees, all the reports said just that. For example, the Senate Judiciary Committee said, the provisions on judicial review seeks merely to restate the several categories of questions.
Doctor, could you please pull that microphone closer to you? Still not working. Excuse me a moment. I don't mean to interrupt you, but we seem not, the stenographers. Okay, can you even get a,
Oh,
there you go.
the button was not pushed.
All right.
So I hope I don't have to repeat my entire testimony. So I'll just go ahead. Okay. So the third group that understood the APA to merely restate existing law was the courts. After the APA was adopted, the courts did just the same thing that they did before the APA. They gave deference on fact questions and mixed questions, but they gave no deference on issues of law. If the Supreme Court had understood the APA to change the scope of judicial review, then the APA's adoption would have caused the court to change its approach, but that did not happen. To sum up, the APA's provisions on judicial review are inconsistent with the Chevron Doctrine. The Chevron Doctrine requires courts to give deference to many agency decisions of law. The APA says the opposite. It explicitly requires courts to give no deference to agencies' decisions of law, and the APA's legislative history confirms this. Suppose that people who were involved in the passage of the APA took a time machine to today, they would be shocked at the Chevron doctrine. Indeed, it's easy to understand why the Chevron doctrine appeared only 38 years after the APA's adoption and not sooner. For many years, memories of the APA's true meaning were fresh. Only when memories started to fade or to die out could the courts adopt an approach that ignored administrative law's fundamental statute. Thank you very much.
Thank you. Professor Pierce.
Thank you, Chairman Marino, Ranking Member Johnson, and distinguished members of the subcommittee for providing me the opportunity to testify today. I just wanted to go through a couple of basics to start with. First, courts always have and always will confer some degree of deference on agencies when they act because of comparative institutional expertise. The agencies know more than the courts about the subject matter that they're addressing, and that's why, presumably, Congress gave them the power and not the courts the power to implement the statutes at issue. Second, courts always reject any agency action if it's inconsistent with a statute or if it's arbitrary or capricious. That's, again, something that's been around for a very long time and hasn't changed, didn't change with Chevron, hasn't changed today. And then courts uphold agency actions in about 2/3 of the cases that come before them, no matter what doctrine they apply. There's been study after study of all of these doctrines, and what they show is like a 2% difference in rate of upholding. The doctrines are not very important. Now, when Chevron was first decided in 1984, I set forth in a number of articles and books my reasons why I thought it was sensible and consistent with both the administrative procedure and the Constitution. I also predicted that it would have a big effect. Well, I was totally wrong in my prediction. Time has proven me wrong. Between 1984 and 2001, it had a fair amount of effect in the circuit courts. Circuit courts' rates of upholding agency actions went up during that period of time. Since 2001, there's very little evidence that it's had any effect in the circuit courts, and there's never been any evidence that it's had any effect on the actual decisions of the Supreme Court, as opposed to the way that they frame their decisions. Just to give you an example of the difference between the two, Justice Scalia was the strongest proponent of Chevron. He expressed that view in opinion after opinion and a famous law review article he wrote in Duke Law Journal. He also is the justice who votes least frequently to uphold agency actions. By contrast, Justice Breyer has always been a strong critic of Chevron, and he's the justice who votes most frequently to uphold agency actions. So there's really no evidence today that Chevron is having any of the effects that some people attribute to it, and very little evidence that it ever had those effects in terms of actual Supreme Court opinion. The Supreme Court has the power to change its doctrines. It changes its doctrines all the time. It also has the discretion to apply its doctrines in different ways, in different cases, and to tailor the doctrines to the facts of the cases. And that's what they're doing. And the evidence is, as I indicated in an article that I included as an appendix to my testimony, that the degree of deference is going down. It's gone down over the last several years. So there's really no reason for concern at all, and I can see absolutely no reason why you'd want to take legislative action in this area. Thank you.
Thank you, Professor Hammond.
Thank you, Chairman Marino, Ranking Member Johnson, Ranking Committee Member Conyers, and distinguished members of the subcommittee for the opportunity to testify today. We ask a great deal of courts when they review agencies. They police jurisdictional boundaries, they guard against serious errors, they incentivize agencies to engage in legitimizing behaviors like promoting participation, deliberation, and transparency. Now, these things could be achieved with de novo review, but there are important reasons for giving deference to the agencies. Agencies have experience with the statutes that they administer. Relative to the courts, agencies have superior expertise, particularly with respect to complex scientific and technical matters. And deference is an exercise in judicial self-restraint. By deferring to agencies' reasonable explanations, rather than substituting their own judgment, the unelected courts can avoid injecting their own policy preferences into judicial review. Judicial review attempts to balance all of these competing considerations. Now, the topic of this hearing is Chevron, but I want to emphasize the empirical research that suggests that the court applies Chevron to less than half of the agency interpretations that are Chevron eligible. There is a whole spectrum of deference regimes that are tailored to the variety of agency actions as the particular circumstances warrant. Those approaches should be viewed together as part of a system. Deference is also not a rubber stamp. Under hard look review, for example, agencies must provide reasoned explanations for their interpretive choices or policy discretion. In other words, they must earn their deference. By the way, this requirement of reason giving helps alleviate constitutional concerns about the administrative state. There are also times when deference is not warranted at all. For example, an agency cannot use a limiting interpretation to cure a statute that is defective on non-delegation grounds. There are also a few very unusual cases in which the court has determined that Congress did not intend the relevant agency to exercise interpretive authority. FDA versus Brown and Williamson and King versus Burwell are examples. Finally, I want to contextualize this system of deference with a matter of remedies in administrative law. The deference regimes work together with the remedies. For example, if courts find an agency action is unlawful, they also assess the particular circumstances to decide whether to remand with or without vacating the agency's action. The point here is, yes, the system is imperfect, but attempts to legislate a fix to a particular deference doctrine are not likely to be effective. The better approach is to craft agencies' statutory mandates with particularity to either expand or cabin agency discretion in the first instance, as this institution sees fit. Thank you again for the opportunity to testify, and I look forward to your questions.
Thank you, Professor Beerman.
Thank you, Chairman Marino and Ranking Member Johnson, and the distinguished members of the committee. It's an honor to appear before you to testify about Chevron. I've been teaching and writing in the administrative law field for about 30 years now, and in particular, I've written a couple of articles that are highly critical of the Chevron doctrine, which were included in your materials for today's hearing. Now, I had part of my opening remarks were going to be to repeat some of the criticisms you've heard of Chevron, but I apologize, Mr. Johnson, that I couldn't come up with a metaphor about chickens or foxes, but I think it would be beating a dead horse somewhat. So I'm going to refrain from using part of my time for that. And I want to say that one of the things that we've seen over the last couple of terms of the Supreme Court is some sense there that more of the justices are starting to feel uncomfortable with the Chevron doctrine, but I really think it's overreading them to say that the Chevron doctrine is about to be thrown out. That's been going on since the beginning of the Chevron doctrine. There's always been this disagreement. More than once, Justice Scalia, may he rest in peace, complained that some decision had just eviscerated Chevron, but yet Chevron limped along, sometimes resulting in extreme deference to agencies and always creating confusion and uncertainty. And I think that one of the effects we need to think about is the fact that it encourages agencies to be more adventurous in their statutory interpretations, so that regardless of what the result is going to be at the court, the agencies can feel that they can go farther away from Congress's expressed intent when they're interpreting a statute. Now, substance aside, in my opinion, Chevron has failed as a matter of legal craft, in the sense that, remember, it's a decision procedure, a framework for decision. It's not a substantive rule itself. And yet there's so much uncertainty about how it applies that it's really failed as a decision procedure. There's a big issue about how it relates to the arbitrary, capricious, and abuse of discretion or otherwise not in accordance with law standard that governs under the Administrative Procedure Act. Are Chevron decisions about policy or about statutory interpretation? There's one line in cases that says that pure questions of statutory interpretation are for the courts, which throws into doubt what Chevron is actually about. And I don't think anyone favors giving the sort of extreme deference outlined in Chevron Step 2 to agency policy decisions. Rather, what we want is for careful consideration of whether the agency examined the relevant factors, employed the correct legal standard, applied its expertise when making its decisions. And many of the decisions reviewed under Chevron turn out to be really policy decisions, not statutory interpretation decisions. So what I want to do now is look forward to the idea of a possible statutory reform, and I spelled this out in my complete testimony before you, a proposal that I think will reorient judicial review of agency action towards the will of Congress. And the text as I spelled it out is as follows. Unless expressly required otherwise by statute, the reviewing court shall decide all questions of law de novo with due regard for the views of the agency administering the statute and any other agency involved in the decision-making process. And the words due regard, they're not certain. There is some historical precedent for the use of those words in such a statute. And it would make clear to the reviewing courts that they have the primary responsibility for ensuring that agencies follow Congress's instruction, while acknowledging that there's room for deference when deference is warranted. So courts under this standard would apply the traditional Skidmore factors of consistency, deliberation, thoroughness, and persuasiveness, but they wouldn't be locked into these standards because there may be other factors that may seem relevant in a particular circumstances, and the courts would be free to do that. Now, of course, this would not come anywhere close to eliminating all uncertainty in judicial review. It wouldn't become mechanical by any means, but it would eliminate the epic battles we see today about whether and how Chevron applies, and it would head off the sort of extreme deference to agencies that, in my opinion, often thwarts serious examination of legislative intent. Now, one important point about this, Justice Scalia, in his defense of Chevron, was very concerned about flexibility. He viewed one of the virtues of Chevron that it preserved agency flexibility to change its views as conditions warranted. Now, and in his opinion, once Skidmore deference would apply, this sort of deference, that the agency would be locked in to whatever the court approved. And I don't think that's actually necessary. I don't think this is insurmountable. I think courts could, in my opinion, they could, consistent with the rule of law, allow for continued agency flexibility whenever an agency interpretation had been accepted under the new due regard standard, as long as it's clear that the decision was made with substantial deference to the agency. Now, a bigger question has been raised by some of my co-panelists is whether this would actually make a difference. As I point out in the articles included with this testimony, at least at the Supreme Court, the cases seem to be more decided along the ideological dividing lines that we are all familiar with at the court, rather than on differing views of deference. Now, that may be true, but I think it would be less so if the governing standard of review nudged the courts more toward careful consideration of legislative intent. Chevron is a distraction from what should be the two key issues in judicial review, congressional intent and sensible policy. And some sort of reform, whether my proposal or something else, ought to reorient the law in that direction. Thank you.
Thank you, Professor. Each of the witnesses' written statements will be entered into the record in its entirety. We will now move to the Congressmen and women's 5 minutes of questioning, and I will begin by recognizing myself. Professor Turley, in Federalist 51, James Madison wrote that the Constitution's separation of powers was structured to make, quote, ambition counteract ambition, end quote, between Congress, the executive, and the judiciary in order to preserve liberty. How does the Chevron doctrine alter the incentives of the three federal branches to undermine the checks and balances system?
I think it's a critical component in terms of the rise of this administrative state. And I do think that we have to be honest, that the creation of this effective fourth branch was not part of the original design. It creates new pathways, new centers within the system. And we have to be at least concerned about how, for example, administrative courts have become the dominant forms of adjudications in our systems. It wasn't designed for that. And yet when citizens go to those courts, they find they have fewer rights. They find a system that many view as fairly heavily weighted towards agencies. And so I think that if you look at Chevron in that context, you see that it's actually undermining both legislative and judicial functions within the system. And where I disagree with my esteemed colleagues is I don't see any cognizable principle at all coming recently out of the Chevron cases. The court seems to think that putting additional layers of ambiguity onto Chevron will create clarity, and it hasn't. It's in the last case in King v. Burwell, when we were looking at what's the dividing line, what's the role of courts, the court says, well, this is a question of deep economic and political significance, and seemed to avoid the Chevron analysis. That's no better than Chevron itself. We have this confusion in this area that's very, very dangerous in terms of legislative authority, in terms of judicial authority.
Thank you. Professor Shepard, Dr. Shepard, one of the great oddities in modern jurisprudence is that the courts have never really explained how Chevron deference is consistent with the APA, which prescribes a standard of judicial review that seems to preclude deference to agencies' interpretations of the statutes. But odder still, your written testimony suggests that the legislative history of the APA demonstrates that Congress in 1946 actually refused to adopt a deferential standard of review similar to Chevron's. Can you explain that in more detail, please?
Yes, but what he's referring to in my written testimony, the majority, there was an Attorney General's Committee on Administrative Law that produced two reports. One was the majority report, which was more in tune with the New Deal liberals, and the minority report, which was more conservative. The majority report proposed an approach like Chevron. It suggested that that might be a good idea. It was proposing that to the courts. However, the statute that eventually became law, the APA, did not include that proposal. So that was rejected. The APA was a compromise, and the compromise that ended up had some things for conservatives and some things for liberals, and the compromise did not include that Chevron approach. Now, the question of how did Chevron possibly occur, given that the APA is very clear that there should be no deference on issues of law? Time passes. I don't know. It's a puzzle.
Thank you. Professor Duffy, how can it be that in all these years since Chevron, the courts have never grappled with this legislative history of the APA that shows how Chevron is flatly inconsistent with the specific legislative compromise reached in the APA?
Well, I agree that it is a mystery. Indeed, I think that my colleague, Professor Hammond, said that this doctrine of Chevron is a model of judicial self-restraint. And really, I think it's quite the opposite, because there was a specific statute that governs judicial review. And not only did the court go against the history, but it didn't even attempt to read the statute. It didn't even engage in the statute, and it still hasn't engaged in the statute. Indeed, some of the oddities is that Justice Scalia, at times even in his writing and recently in a judicial opinion, recognized that the Chevron doctrine seemed to be completely inconsistent with the APA. So it is a mystery, and I think that creates the confusion too, that you've got one set of principles like Chevron with its two steps, and then you've got the APA, and that those two things keep passing in the night. So I think that is unfortunate.
Thank you. My time has expired, and the chair now recognizes the gentleman from Georgia, Congressman Johnson.
Thank you. On occasion, Congress passes broad and open-ended laws, leaving it to federal agencies to fill the gaps of delegated authority through regulation. This has been the case since the times 1790s that you cited, Professor Turley. Do you believe that the level of public safety regulation in 1790 is appropriate, is an appropriate benchmark to compare today's administrative process to?
No, that's a valid point. There's no question that the federal government has changed, and this is a new reality. I don't believe that that warrants the type of change that has been brought forth in Chevron. In fact, back in that day, the framers were concerned with what was called the royal prerogative that James I talked about, where he said that really passing legislation is just the beginning of the process and that he uses his own logic to improve it. And the framers rejected that. And I think Chevron creates a sort of agency prerogative, where agencies treat legislation as just the start of the legislative process. I think that's dangerous for legislative authority.
What do you think that the legislature then should draft more specific legislation? Is that the solution rather than judicial scrutiny? Can we apportion some of the blame that we are assessing to the judicial branch to the legislative branch in terms of its inability to formulate strict, all-encompassing legislation that needs no rulemaking?
That's a very valid point again, and I do want to differ in one sense.
Is it practical? Is that practical though?
Yeah, I believe it is practical in the sense that
in this
obviously
Congress?
agencies are going to have interpretive roles. There's applications to laws that are going to deal with questions that this body cannot answer. What I think is dangerous about Chevron is the assumption that there's an implied delegation of Congress to have agencies perform this legislative role. That's what I reject. I think that's a very dangerous presumption to make because it robs this institution of a very important role. Congress is so vital to that tripartite system because it's in this body where factional disputes result in majoritarian compromise, at least ideally they do. But this is where that magic is supposed to happen. If you shift the center of gravity over to agencies performing a legislative role away from you, that doesn't have the same impact politically the framers wanted.
Okay, thank you. Professor Hammond, what is your response to Professor Turley's remarks?
Well, first of all, I'd like to say about this idea of implicit delegation of interpretive authority. The courts themselves recognize that that is a fiction. The courts have adjusted the deference doctrines and the standards of review to the fact of broad delegations of authority. So, for example, while the non-delegation doctrine is a very easy test to pass, agencies are required to provide reasons for what they do. There is no presumption of regularity in the same way that a court reviewing a legislative enactment would provide. And so when courts are reviewing agencies, by asking the agencies to explain themselves, not rubber stamping what they do, courts are actually fulfilling a constitutional role themselves and policing the boundaries of what agencies are doing.
Thank you. Professor Beerman, as a general matter, do you endorse enhanced judicial review when it comes to deregulatory actions?
Well, you see, that's a great...
Yes or no?
Yes. And I think that raises a great point
refreshing.
about the origins of Chevron, because Chevron was a decision in a period of deregulatory government action. And it was originally the proponents of Chevron were the people favoring less regulation, and the opponents of Chevron were people favoring more regulation. It was viewed that what was going to happen under Chevron was it was going to let the agencies get away with more deregulation, contrary to what Congress had said in the statutes. And I think that's the important point. To me, I think I'm just completely neutral on what the substance of the Congress's output is. To me, the appropriate focus for judicial review should be on what Congress wanted the agency to do. And I think too often the Chevron doctrine allows for the courts to ignore what Congress wanted the agencies to do, regardless of whether it's regulatory or deregulatory.
All right, my time is up. Thank you. I yield back.
Chair now recognizes the gentleman from California, Congressman Issa.
Thank you. Thank you, Mr. Chairman. Professor Turley, good to see you again.
Thank you, sir.
I'm going to address this to you, and as we go up and down the dais, I have no doubt that many of the questions will be similar to this. But earlier today, we had a lengthy hearing in which DACA, executive action that has not been stopped, but clearly is not a court decision, and the Affordable Care Act, where there's been multiple decisions. So I'm going to focus on the Affordable Care Act for this afternoon. In that hearing, we seem to hear, essentially, we commend the court, led by Justice Roberts, in ignoring a few words in the act and looking at the meaning. And to a certain extent, that's what we're talking about this afternoon, that Chevron is, in fact, ignore the words, focus on the meaning. Would you say that's a fair recognition of what, if you will, the doctrine asks the court to do, or the court under that doctrine asks itself to do?
Well, I would certainly agree to the extent that I believe that Chevron gives license for analysis that that ignores the text. In fact, Chevron itself ignores the text of the APA, which is Section 706. This body actually did a good job in saying this is the function of the court. If you read Section 706, it makes abundant sense, and the court simply ignored that language, and I think it's ignored.
And that's where my question leads. Thank you, Professor. You've done it again. You've anticipated. In this body, in future legislation, limiting the court by deciding that what is in a particular law is all that there is, would use similar language to the Affordable Care Act. We would say, you know, if there's any ambiguity, come back to us. No extension beyond explicitly those granted shall be there. The words would probably not be as simplistic and profound as the Constitution, where we've been arguing over what the state has and what the federal government has for years, but it would be similar. You know, federal government only gets such powers as are explicitly given to it. All the rest belong to the states or the people. If we cannot use the language of the Affordable Care Act to make it clear that we don't want limitations, unless, of course, we want them, which is what happened in the first Affordable Care Act portion, how do we structure language as the body, the only body that can make law? How do we structure language to limit the excesses, erroneous conduct, or outright deliberate abuse of laws that allow for regulatory creation?
It's an excellent question. What I suggest in my testimony is that we may want to consider, both in terms of amending the APA to deal with this issue in terms of judicial review, but also the inclusion of what would effectively be a Chevron provision in laws that make it clear that this body is not delegating authority over issues like legal interpretation, certainly not when it comes to
But isn't that what was in the Affordable Care Act that, in fact, the court ignored by finding the ambiguity and thus, you know, applying the meaning? I mean, by the way, I'm one of those people that understands that the Republicans who voted against it knew what they didn't want, and the Democrats wanted the government to pay for, make happen, and so on. I mean, I think Justice Roberts, in a sense, hit one thing right in that case. He did order a solution that allowed the people who voted for that act to get what they wanted. Not what they wrote, but what they wanted. So I sort of reiterate, if it didn't work there, what language would you say would be unambiguous enough to keep lifetime appointments from saying, we see it, but we don't read it? And I'll follow up because my time's running off with the second half of the question is, wouldn't the alternative of expressly having all regulations expire, not just all law, but all regulations expire within a period of time? In other words, can't we make an act and all future acts that say, you know, you may produce regulations, but those regulations have to be codified, otherwise they're only good for 5 years or until the reauthorization of the act. Isn't ultimately a time limit on regulations a better solution than, in fact, trying to say you won't go there when, in fact, there's a record that going there doesn't have a penalty sometimes?
Well, I clearly disagree with aspects of the ACA rulings by the Supreme Court. We agree on that. I do think that you have the authority to do precisely that. I also thought that you have authority to have a congressional approval statute along the lines of the REINS Act. All of that, I think, is within the power of Congress. I think what you have to do is this body has to be aggressive in trying to get back this authority. The court has made a colossal mess of this area, particularly on Chevron. I don't know anyone that would think that Chevron at this point that we have an absolute certainty on this, behind this table of what Chevron even means anymore, except that it insulates agencies from effective review.
Mr. Chairman, thank you very much. I appreciate, I would have liked to have heard from all the witnesses, but I understand the limited time, and I yield back.
Chair now recognizes the gentlelady from Washington, Congresswoman DelBene.
Thank you, Mr. Chair, and thanks to all of you for being here with us today. Professor Hammond, I wanted to ask if you are familiar with the U.S. Department of Education's gainful employment rule. I'm not. So the gainful employment rule is an attempt to, or has been an attempt to define gainful employment so that taxpayer-funded financial aid for career education programs is actually going to students who are really being trained for real careers and attempt to deal with some of the challenges that they've seen, especially with for-profit colleges. I bring that up because when the Department of Education first put the rule in place, it was challenged and struck down. But in that case, the judge did uphold the Department of Education's authority to issue regulations enforcing the gainful employment requirement in the relevant statute. The judge commented that, quote, the department had gone looking for rats in rat holes as the statute empowers it to do, end quote. The Department of Education went back to the drawing board and after notice and comment put forward a revised rule, and that rule was upheld in court just last week. Now it seems that this is a pretty good example of the process working well, where a problem impacting families was identified, the relevant agency acted within the authority that Congress granted it, and through a transparent and accountable process, a solution was formed. So I wondered if you think that do we put this process at stake if we start tinkering with the current legal framework by putting together piecemeal legislation?
Yes, that's a great question, and I have published an article in the Columbia Law Review on this issue of what I call serial litigation. So an agency's action is challenged, it's remanded, the agency then corrects itself, the action is challenged again, and courts very often do reward agencies the second time for paying attention. Our current deference regimes enable this kind of dialogue. When courts explain in the first instance what the agency has done wrong, but remand to the agency for a chance to fix it, this furthers the responsiveness of our administrative state. It's acting within the bounds that the courts have reiterated, and then when it does that, when an agency does that, deference the next time around is appropriate.
So do you think that it's possible that legislation could actually create new or worse in some cases legal uncertainties in cases where the agency rulemaking actually seeks to and clarify, in this case, an ambiguous part of the law that Congress chose not to define?
Yes, if we ask courts to review de novo, we lose that ability to really bring in the expertise of the agencies and the responsiveness in a dialogic kind of way with, between the agencies and the courts.
And so if we in Congress want to be crystal clear and preempt agency rulemaking on a particular point in legislation, obviously we can do that through careful and considered drafting ourselves. Isn't that correct?
That's right.
Professor Pierce, I wondered if you had a comment on this, on the rulemaking, the example I brought up, and also on whether you think legislation can be helpful or would create more uncertainty.
I actually think over time it would have no effect at all. And this goes back to where I was totally wrong on Chevron. I looked at Chevron, I said, I thought it made sense. Maybe I'm right, maybe I'm wrong, but I wrote a bunch of books and articles about how good it was and then about how much change it hasn't. And I don't think changes in tinkering in language. You know, they're always going to be deferring. They have to defer. They don't know much about nuclear energy. They don't know much about water pollution. The agencies know much more about it. So there's always going to be a degree of deference, and there's always going to be, on the other side of it, a tendency to check to make sure they only do things that they can explain pretty well, and that they only do things that are within statutory boundaries. And that's the nature of the beast, and you can describe it 100 different ways, and not going to change what the courts actually do. I have to say that one of the problems, going back to an earlier exchange, one of the problems, there are horribly drafted bills. The Chief Justice added a paragraph in his opinion in King versus Burwell in which he alluded to the process through which that legislation became law. And it was a process that led to a mess, where it's very difficult to reconcile the purposes of one part with the language of another part. And the Clean Air Power Plan has a bigger problem that in 1990, the House put one provision in Section 111, and the Senate put another provision. They are totally inconsistent, and then both were enacted. And
my
so
time's
the
expired.
courts have to decide which of the things that the Congress said to take seriously, because one says yes and the other says no.
Thank you. I yield back, Mr. Chair.
Okay, the votes have been called. We're going to try and get the other two gentlemen in before, because I don't want you to have to wait here for a half hour. So the chair recognizes the gentleman from Texas, Mr. Radcliffe.
Thank you, Mr. Chairman. So I've only been in Congress for the last 15 months, but in that period of time, I've already been able to have hundreds of conversations with small business owners and farmers and community bankers, independent insurance agents across the rural Northeast Texas district that I represent, that all those conversations end in frustration over the endless burden of regulatory agencies and rules. Sometimes it relates to Obamacare, sometimes it relates to the EPA regulating puddles in people's backyards, or trying to tell my constituents what kind of light bulbs they have to buy. And this frustration is really heightened because when I came into Congress, I came in as part of a historic majority here in the House and as part of a Congress where we took over control of the Senate as well. And I think my constituents expected things to change, hoped that Republicans would put a stop to a runaway administrative state in this country. But admittedly, very little has changed. And we can talk about executive overreach, but I'm willing to admit and acknowledge that part of the problem here is legislative underreach. And with respect to the Chevron doctrine and other things. So I'm certainly grateful that we're having this hearing today. We have an opportunity to talk about the possibility of solutions to this pervasive problem. And so I want to start with you, Professor Turley, because in your written testimony, you said that, and I'll quote you here, fear that the growth of federal agencies is reaching a critical mass within our system, a point where rapid, exponential, and irreversible expansion will occur. So in your opinion, first let me ask you, what are the greatest drivers of this agency expansion, and where does Chevron fall on that list?
Well, thank you very much for that question. I think that the danger itself is existential for the system. I happen to agree with many things that agencies do, but for us to pretend that this isn't a new system with new dimensions of power and pathways is to ignore reality. Part of the frustration that your citizens have is they sense correctly that the center of gravity of the government has shifted away from them, that they're more the subject of government power than the source of government power. And I do think that that's a legitimate concern, and I think Chevron is part of that. If you want to deal with the independence of agencies, you have to deal with the insulation of agency decisions that is exposed in Chevron. But Chevron also captures this idea that the administrative state is a new reality. When we hear some of my colleagues talk and they say, well, we have to assist the administrative state. And that's exactly what it is. It's becoming a state with legislative and judicial and executive powers combined. And I think that would horrify the framers.
So I'm going to ask you to speculate here. Let's say that Congress were to pass legislation essentially overturning Chevron, and a president, not necessarily this president, were to sign that into law. In your estimation, how far would that go in addressing this vast agency expansion that we're talking about?
Well, it would not dismantle the administrative state, and I think we all have to accept that there's going to be a role of federal agencies. This is part of this large government that we have, but it's a very important first step. I think the court should look at things like the REINS Act and other ways to force agency decisions to come back before Congress. But the most important thing about attacking Chevron is to tell courts that you're wrong. You can't just imply that we are delegating legislative authority to the agencies every time you have ambiguity, even on legal questions. And you certainly can't do that on a question of jurisdiction. That's why the City of Arlington case really is so chilling for me, is that we always assumed that would be the Rubicon, that at least agencies wouldn't get deference on defining their own jurisdiction. And I think Congress needs to attack that very aggressively.
Thank you. Professor Shepard, I want to give you an opportunity to talk about an issue that I noticed from your testimony. One of the oddities here in modern jurisprudence is the fact that courts have never really explained why the Chevron deference is consistent with the APA, which prescribes a standard of judicial review that seems to preclude deference to agency interpretation of statutes. Your written testimony suggests that the legislative history of the APA demonstrates that Congress, in fact, actually refused to adopt a deferential standard of review similar to Chevron. I want to give you an opportunity to explain that.
I've already mentioned that briefly. That's exactly what happened. There was a proposal from an Attorney General's committee to allow Chevron-style deference, and that proposal did not find its way into the ultimate compromise.
Well, thank you. My time's expired. I did want to, Professor Duffy, I appreciate your comments regarding a de novo standard, and I will tell you that I agree with you, and I'll yield back.
Thank you. The chair now recognizes the gentleman from New York, Congressman Jeffries.
I thank the chair, and I thank the witnesses for what has been a very thoughtful discussion. Professor Turley, is it my understanding that one of your concerns with the Chevron doctrine is that the courts seem to be coming to the conclusion that the ambiguity in a statute effectively means that Congress is delegating authority to the administrative agencies. Is that right?
Well, there's an assumption of implied delegation that underlies many of these cases that I think is misplaced. It gives agencies, in my view, too much insulation from review under the Chevron doctrine.
Now, would you agree that there's been an active discussion around the rise of the regulatory state that perhaps even dates back to Justice Scalia's days as a university professor, connected to an article that he wrote, I think it was in 1981?
Yes. Yes, I think so.
And so that essentially means that for at least 35 plus years, there's been this concern that an administrative state, a fourth branch of government, has arisen, and the linchpin for it is the ambiguity that continues to exist coming out of bills passed by this House and that Senate, correct?
Yes, I would qualify it in this one respect, that as I do agree with an earlier statement made, that there are statutes that have gone to the court that I don't consider to be ambiguous, but have been, the interpretation has been yielded to federal agencies, in my view, improperly by the courts. And I think that undermines both the judicial branch and the legislative branch.
But would you agree that it certainly is the case that in many instances, the statutes that are being passed by this Congress remain broadly vague in ways that allow for perhaps judicial overreach?
Well, that's certainly the case in many statutes, yes.
And so at a certain point, don't you think that it's reasonable for the courts to assume not just that there's implied delegation, but that the absence of a mechanical, precise focus by this Congress over decades, notwithstanding the active debate and the view by many that there's been judicial overreach, to continue to send out statutes that are vague, at a certain point does seem to me perhaps that some could reasonably conclude that Congress is implying we don't have the expertise, we don't have the time, we don't have the tolerance to enact these statutes in a more precise fashion.
I think that's an excellent point. I would qualify it in two respects where we may disagree. One is that part of the problem with the Chevron doctrine is that the court is putting these layers of ambiguity on Chevron to the point that you have the deference, but the rationales change. And I think that's dangerous. Second, I don't think Congress does imply delegation for legislative actions. I think that there are lots of reasons why there's ambiguities, but nobody here is suggesting that agencies shouldn't interpret. No one's suggesting that they shouldn't get that the court should not defer to some extent. The question is the extent, and it certainly should not extend to legal reasoning or jurisdictional questions, some of the reach we've seen with Chevron. But agencies are going to be given a certain amount of weight. That was what happened under Skidmore. Chevron solved a problem that didn't exist in my view, and it's made it a lot worse.
Now, in terms of sort of the original intentions of the founders and thinking about sort of how Congress was constructed and the notion that every member of Congress would be a generalist and then there would be a subset of specialists who would work through the committee process. Is that a reasonable definition of how Congress at least has evolved and been thought of in terms of the framers' intentions?
Well, I think you're right about being generalist, but I would caution that the framers believed that the structure of the system would actually help direct compromise, would help diffuse divisions by reaching majoritarian compromise. What has happened is that we've created this whole new bureaucracy of the administrative state, which is answering those questions that were supposed to be answered here. And whether it's convenient or not, I think it has pretty dire consequences for our political system.
Thank you for that. And I would say that I do think that Professor Pierce's observation about the expertise necessary in an increasingly complex society that is possessed in some regard, and I certainly have great respect for Chairman Marino and others on this panel who've got a certain subset of expertise, particularly in law enforcement, but that in some of these other areas, whether it involves the energy sector, food safety, toxic water, that there is a degree of administrative expertise that exists most specifically at these agencies, and that in some sense it is reasonable for there to be some understanding of deference given to them. And I thank you all for your thoughts, and I yield back.
Thank you.
Thank you. This concludes today's hearing, and thanks to all our witnesses for attending. Without objection, all members will have at least 5 legislative days to submit additional written questions for the witnesses or additional materials. For the record, this hearing is adjourned. And we have to run to vote.